All right, so get ready, because today we're diving deep into Cambodian history, specifically their law on marriage and family from 1989.
Ooh,
Yeah, you
fascinating.
sent over some excerpts from the actual law, so we're going right to the source,
That's awesome.
It's like a stepping back in time to see how a country rebuilds after, after a really turbulent period,
Yeah.
and how they try to redefine, like, what family life looks like.
That's exactly what makes this law so interesting. I mean, it's more than just legal jargon. It's a window into their society.
Yeah.
Like, as they're reshaping their values and priorities, imagine, emerging from the Khmer Rouge regime and needing to establish a new sense of normalcy.
Right.
This law was part of that.
It really sets the stage, doesn't it?
Absolutely.
And one of the things that I thought was really interesting right away was how they define marriage.
Okay.
It's a solemn contract.
Yeah.
It's not just I do. It feels much more serious than that.
It does.
It's very deliberate.
Absolutely. And I think that wording really reflects a conscious effort to move away from the instability of the past, and to really emphasize lasting commitments.
Right.
You can almost feel the weight of history.
Yeah, you really can.
Behind those words.
So let's say you're getting married in Cambodia in 1989. What are the must-haves to make it official?
Well, first of all, it had to be a voluntary union between a man and a woman, which was in line with the cultural norms of the time. Article 3 lays that out pretty clearly.
Yeah.
No forced marriages or anything that went against free will.
Makes sense. And of course, there's the age factor.
Yeah. Article 5 sets the minimum age, 20 for men, 18 for women.
Okay.
But, and this is interesting.
Right.
There's an exception. If a woman is pregnant, they can marry younger as long as they have parental consent.
Oh, okay. So it's not like a hard and fast rule.
No.
There's some flexibility for unique circumstances.
Yeah, exactly.
Are there any, any deal breakers, like things that would absolutely prevent a marriage from happening?
Definitely. Article 6 lists a number of prohibitions, including same-sex marriage, which was not legally recognized at the time.
Right.
It also prohibited marriage if one person was impotent, had certain diseases like leprosy or tuberculosis, or a mental incapacity. Okay. And of course, polygamy was, a no-go.
Makes sense. Those prohibitions seem to align with a lot of other marriage laws around the world.
Yeah.
What about marrying relatives?
Oh, yeah. Cambodia has strict rules about that, too.
Okay.
Articles 7 and 8 prohibit marriage between close relatives, both direct line, parents, children, grandparents, and what are they called? Collateral relatives. Yeah. Siblings, cousins, aunts, uncles. Right. Up to a certain degree of kinship.
So, like, preventing potential genetic issues.
Exactly.
Maintaining clear family structures.
Yes.
It makes sense.
But here's where it gets interesting.
Okay.
Article 8 also has this exception that allows remarriage to certain relatives after a spouse dies.
Oh, okay.
So it's like they recognize that family ties might shift and change after a loss like that.
Okay, so it's not just about imposing strict rules.
Yeah.
They're also trying to accommodate the complexities of real life.
Exactly.
Okay, so remarriage was allowed. But was there a waiting period involved?
Yes, and this is where it gets really interesting.
Okay.
Article 9 introduces what they called the legal period of conception, which required a woman to wait at least 300 days
300 days.
After the end of her previous marriage before she could remarry.
That's almost a year. That's a long time.
It is a long time.
Why such a long wait?
Well, it all comes down to establishing a clear line of paternity and avoiding any ambiguity about who the father of a child might be. Imagine, a woman remarries before those 300 days are up and then gives birth.
Yeah.
The law presumes her new husband is the father.
Oh, wow.
Even if the child was conceived during the previous marriage.
That's a big deal.
Yeah. So it was all about preventing paternity disputes.
Right.
And protecting everyone involved, especially the child.
So let's say somebody had an issue with the marriage, like they believed it shouldn't have happened. Was there any way to, like, challenge it or object?
Yeah. There was a process for that outlined in Articles 15 through 20.
Okay.
It allowed relatives or anyone with a legitimate interest to file a complaint within 10 days of the marriage announcement being posted publicly.
Publicly?
Yeah.
Interesting.
But they couldn't just object for any reason.
Right.
They needed valid grounds. Like, proving one of the people was underage
Mm-hmm.
or already married,
Oh, wow.
or that the marriage violated one of those prohibitions we talked about.
Right, so there was like a system of checks and balances
Yeah.
to make sure marriages were legit.
Exactly.
What about situations where, like, a marriage was considered invalid right from the start?
That's where the concept of void marriages comes in.
Okay.
Covered in Articles 21 through 28.
Okay.
There were certain circumstances that could automatically, like, nullify a marriage,
Mm-hmm.
like if it was forced,
Right.
or if one of the parties was underage,
Yeah.
or if one person was already married. So basically, bigamy.
Okay.
Mental incapacity could also make a marriage void.
Right.
But if the person recovered, the marriage could potentially become valid again.
Oh, that's interesting.
Yeah,
That's a pretty significant detail.
it is.
What about the implications for, like, children and property?
Right.
If a marriage was declared void, would it be like the marriage never happened?
Not exactly.
Yeah.
Children born during a void marriage were still considered legitimate.
Oh.
And in terms of property, it was handled much like a divorce would be.
Interesting. So it wasn't completely erased,
No.
at least not in terms of the impact on the children.
Exactly. And I think Article 28 is important because it highlights the official process.
Okay.
The court would issue a formal annulment,
Mm-hmm.
and the registrar would update the marriage certificate to show it was no longer valid.
So it's all about maintaining clear legal records.
Exactly.
Sounds like they wanted to cover all their bases, make sure
Mhm.
everything is properly documented.
Absolutely.
Okay, so let's shift gears a bit and talk about what happens.
Okay.
Once a marriage was considered valid,
Mm-hmm.
what did the law say about the rights and responsibilities
Right.
of the husband and wife?
This is where Article 29 makes a powerful statement,
Yeah.
especially for 1989.
Okay.
It declares that husbands and wives are equal
Okay.
in all aspects of the family.
That's pretty bold,
It is.
considering the historical and cultural context.
Absolutely.
Was it truly a commitment to gender equality, or were there some nuances to that?
I mean, it was definitely a step towards greater equality within Cambodian families,
Yeah.
especially after, the Khmer Rouge era, which really disrupted traditional family structures.
Mhm.
It was a way of saying we're starting fresh.
Yeah.
And everyone has a role to play in rebuilding our society.
Yeah.
But as we dig deeper into the law,
Right.
we'll see how that ideal of equality, is sometimes bumped up against other social norms and practical realities.
It's like a balancing act,
It is.
striving for progress,
Yeah,
but also acknowledging existing cultural norms.
exactly.
So Article 29 sets the stage for equality.
Mm-hmm.
But what about the nitty-gritty details? What
Okay.
did the law say about, like, the practical duties
Right.
of spouses within a marriage?
Article 30 outlines those expectations,
Okay.
stating that spouses have a duty to love, respect, care for, and support each other.
So it's about nurturing a healthy and supportive relationship.
Exactly. Marriage wasn't just a legal arrangement.
Yeah.
It was about building, a prosperous and happy family.
Right. Together.
Together.
What about choosing jobs
Yeah.
or participating in society? Were there restrictions?
Well, Article 31 specifically addresses those rights,
Right.
stating that both spouses have the right to choose their own jobs
Well,
and to participate in, political, cultural, and social activities.
so ensuring they had equal opportunities,
Exactly.
not confined to, like, traditional roles.
Yeah.
That's great. It sounds like they're trying to create a more modern and equitable system
Yeah.
for married couples.
Mm-hmm.
But let's be honest,
Okay.
things can get tricky when it comes to finances
Right.
and property.
Absolutely.
How did the law handle those often contentious issues?
Yeah, you're right. Finances can be a major source of conflict
Yeah.
in any marriage.
Yeah.
The Cambodian law addressed this by distinguishing between joint property and separate property.
Okay.
Article 32 establishes that spouses have equal rights
Mm-hmm.
to use, benefit from, and manage their joint property,
Okay.
which is any property or assets they acquired together during the marriage.
Okay, so there's a clear division between what's shared and what's individually owned.
Exactly.
How did they define separate property?
Article 34 outlines that any property a spouse owned before the marriage,
Okay.
as well as anything they inherit,
Oh.
receive as a gift,
Mm-hmm.
or are specifically bequeathed to them during the marriage, remains their separate property.
So protecting what you brought into the marriage,
Yeah.
but also recognizing contributions of both spouses
Yeah.
to the marriage.
Exactly.
Who was responsible for, like, the day-to-day expenses
Oh, good question.
and debts during the marriage?
Article 35 tackles that,
Okay.
outlining that things like household expenses, the cost of raising and educating children, any debts they incurred together, and even maintaining their shared property were all shared burdens.
It's a true partnership.
It is.
Contributing both financially and practically.
Right.
What if one spouse wanted to use or dispose of some of their joint property? Did they need permission from the other spouse?
Ooh, that's a great question.
Yeah.
Article 36 clarifies that each spouse can use the joint property for their needs, but it emphasizes that they have to manage it together.
Okay.
So, for everyday expenses and needs, they had autonomy.
Right.
But if one spouse wanted to do something major, like sell or give away some of the joint property, they absolutely needed the other spouse's consent.
So it wasn't a free-for-all
No.
with the joint assets. It required communication and agreement.
Yeah.
It makes you wonder how these rules played out in real life, doesn't it?
Yeah.
Not all marriages work out as planned,
Right.
even with these well-defined rules.
Unfortunately not.
So that leads us to the often thorny topic of divorce. Yeah. What did the Cambodian law say about ending a marriage?
Article 38 keeps it pretty straightforward,
Okay.
defining divorce as the legal termination of a marriage between two living people who are legally married.
Two living people. Interesting.
Yeah.
What if one of them had passed away, I wonder?
I don't know. That's a good question.
Yeah.
So, under what grounds could a couple actually seek to end their marriage?
Right. Was it just like anything goes, or were there specific reasons?
Article 39 makes it clear that either the husband or the wife could file for divorce.
Okay.
But they had to have a valid reason.
Okay.
It wasn't about just falling out of love.
Right.
They needed grounds that the court would recognize.
Okay. So what were some of those valid reasons for divorce in Cambodia back then? Were they similar to what we see in other parts of the world?
Some of them were, yeah.
Okay.
Article 39 lists things like desertion without cause.
Okay.
Especially if it involved neglecting to support the children. Cruelty, abuse, immoral behavior are also considered valid reasons.
Okay.
Impotence was on the list too.
Interesting.
Which, kind of highlights how important it was for couples to be able to have children.
Right. Yeah, makes sense.
And even being physically separated for more than a year was grounds for divorce.
Oh, wow.
Yeah.
Okay, so they covered a pretty wide range of scenarios.
Yeah.
Could a couple just decide to get a divorce?
Right.
Without, like, a whole legal battle?
They could, and this is where we see a bit of flexibility in the system.
Okay.
Article 40 allowed for divorce by mutual consent.
Okay.
Meaning the couple agreed to end the marriage without necessarily having to prove fault or go through a lengthy trial.
Even if there wasn't a huge blow-up or a major issue,
Yeah.
they could still choose to go their separate ways.
Exactly. It recognized that sometimes marriages just don't work out.
Right.
Even if there's no one to blame.
It happens.
It does.
But even in those cases, there was still a legal process they had to follow.
Right.
It wasn't just a matter of shaking hands and walking away.
Exactly.
So let's delve into those procedures.
Okay.
What were the steps involved when somebody in Cambodia wanted to get a divorce?
Well, first, according to Article 41, they had to figure out which court had jurisdiction over the case.
Makes sense.
It depended on where the defendant lived.
Okay.
So it was all about location, location, location.
Yeah, establishing the right legal venue.
Yeah.
Then what? How did the complaint process work?
Article 42 outlines that the person filing for divorce had to put their complaint in writing, clearly explaining the reasons for wanting the divorce. They could either file it directly with the court or, and this is interesting, with their local People's Committee.
The People's Committee, what was their role?
They played a crucial role in trying to reconcile the couple before things went to court.
So an attempt at mediation.
Yeah.
Before involving the legal system.
Exactly.
That's pretty unique.
It is.
It really emphasizes the importance they placed on preserving families and avoiding like unnecessary legal battles. It's like giving couples a chance to pause and reconsider before making a drastic decision.
They didn't want to just rubber stamp divorces. They wanted to encourage reconciliation. If at all possible.
But of course, not all attempts at mediation are successful.
No, unfortunately not.
So what happened when a case did reach the People's Court?
Well, that's a great question.
It is.
But I think we'll have to save that for part 2.
Okay. All right. So, dear listener, stay tuned for part 2, where we will explore the intricacies of the divorce process in 1989 Cambodia.
Yes, we will.
We'll see how the People's Court handled these cases and what steps were involved in reaching a final decision.
It's going to be good. It's fascinating to consider how even within, a legal framework, there's this attempt at preserving families.
It really speaks to the values they were trying to uphold, right?
Absolutely.
Okay, so we left off with a divorce case.
Yeah.
Landing in the People's Court, what happened next?
Well, Article 43 highlights something, something quite surprising.
Okay.
The court was actually encouraged to try and convince the person who filed for divorce to drop the case.
Wow.
Unless, there were truly serious circumstances.
So it wasn't just about processing paperwork. They were actively trying to save marriages.
They weren't just legal facilitators. They were almost acting as counselors in a way.
That's very different than what we often see in more Western legal systems.
It's just a more community-oriented approach to conflict resolution.
So what if the person was determined to go through with the divorce?
Okay.
Even after the court tried to dissuade them?
Well, then the process moved forward, but even then, the emphasis was on reconciliation.
Okay.
Article 45 states that both the husband and wife had to be called to appear for a reconciliation meeting.
Okay.
Held in private without lawyers present.
So like a safe space to talk things through without the pressure of a formal legal setting.
Precisely. And if that first attempt at reconciliation failed, Article 46 allowed for another meeting to be scheduled.
So they weren't giving up easily.
No.
It's like they really believed in the possibility of a second chance.
It did.
Even, in the face of this marital breakdown.
Absolutely.
This is interesting.
Yeah.
Article 47 states that even if one spouse completely denied the grounds for divorce, the court still encouraged them to reconcile.
Wow.
So even if one person was adamant that the marriage was over, they were still being urged to work things out.
It's really interesting.
I wonder how often those efforts were actually successful.
It would be fascinating to know, wouldn't it?
It would.
It really speaks to a belief in the possibility of second chances.
Right.
Even, when a marriage is really breaking down.
But what if one of the spouses just refused to participate in these reconciliation meetings?
Right.
Were there consequences for that?
Absolutely. Articles 48 and 49 address that.
Okay.
If the person who filed for divorce skipped the first 2 meetings without a good reason, the court could consider their complaint withdrawn.
So you couldn't just initiate the process and then disappear.
No, you have to be actively involved.
Yeah.
And on the flip side, if the other spouse didn't show up for those first 2 meetings, the court could proceed as if they weren't contesting the divorce.
So there were consequences on both sides if they weren't taking it seriously.
Exactly. It shows a commitment to fairness and ensuring both parties had the opportunity to be heard.
What if somebody missed the first meeting? But then showed up for the second one? Was it too late?
Not necessarily. Article 50 says that in that scenario, the court would schedule a third reconciliation meeting.
Wow. They were really giving couples every chance
They were.
to reconcile.
They really were.
It highlights a cultural value that we might not see as prominently in other legal systems.
Exactly.
It makes you wonder if this approach led to fewer divorces overall. Or if it just prolonged the process.
That's a great question.
It is.
Okay, so we have these reconciliation meetings happening. But how long could this whole thing drag on?
Right. Was there a timeline?
Article 51 sets some boundaries. There had to be at least 1 month. But no more than 2 months between each meeting.
So it could potentially take several months to get through this phase.
It could.
And you have to imagine the emotional toll that it must have taken on the couple.
Absolutely.
Especially, if they were already feeling conflicted,
Yeah.
uncertain.
Right. It was not a quick
Yeah.
and easy process.
No, not at all.
And all the while, they were documenting everything meticulously.
Right.
Article 52 mandates that each meeting had to be carefully documented and signed off by the judge and clerk.
Creating a clear paper trail.
Exactly.
Which, I mean, from a legal standpoint,
Yeah.
it makes sense.
It does.
Okay, so we have these attempts at reconciliation,
Mm-hmm.
but inevitably,
Yeah.
some couples just couldn't work things out.
Right.
What happened then?
Then, according to Article 53, it was time for a trial.
Okay, so like a last resort.
Exactly.
Only after all other avenues had been exhausted.
That's a good way to put it.
And even then, there were still potential roadblocks.
Yeah.
For instance,
Right.
if the person who filed for divorce
Mm-hmm.
didn't show up for the trial,
Okay.
without a valid reason, the court could dismiss the case.
That's right, according to Article 54.
So you couldn't just initiate the process
Right.
and then, like, ghost the
Oh,
court.
exactly.
There were consequences for not following through.
There were.
And on the flip side,
Right.
if the other spouse didn't show up,
Okay.
the court could either grant the divorce if there was enough evidence, or they'd have to investigate further if they felt they needed more information.
As outlined in Article 55.
So they weren't just handing out divorces willy-nilly.
No, they weren't.
They were carefully considering the evidence
Yeah.
and circumstances.
They were.
And if the other spouse, like, actively denied
That's right.
grounds for divorce,
Yeah.
the court would order further investigation.
Exactly, as per Article 56.
So it wasn't just like a he said, she said situation.
Right.
They really delved into the facts
They did.
to make sure a divorce was warranted.
It makes you appreciate the level of rigor involved.
It does.
Yeah, it really does. Article 57 outlines some of the investigative tools that the court could use, including, interviewing witnesses, requesting additional evidence from both parties.
Okay, so they were leaving no stone unturned.
They weren't. They were being very thorough, meticulous, which is important, in such a weighty matter.
Absolutely.
As divorces.
Okay, so we've talked about those cases where one spouse is, like, adamantly seeking a divorce.
Yeah.
But what about those mutual consent divorces we discussed earlier?
Right. Article 58 clarifies that even in those cases, the court still had a responsibility to investigate. They wanted to make sure the decision to divorce was truly voluntary. That neither party was being coerced or pressured.
Especially in a society where there might be power imbalances within a marriage.
Absolutely. They were trying to protect vulnerable individuals and ensure that the divorce was a genuine decision.
Okay, so what about those cases
Yeah.
where only one person wanted the divorce?
Right.
What were the court's, like, criteria
Okay.
for granting a divorce in those situations?
Article 59 lays it out pretty clearly.
Right.
The court had to be convinced that there were serious circumstances that made it impossible for the couple to continue living together.
So it wasn't enough
No.
for one person to be unhappy.
Right.
The marriage had to be demonstrably broken.
Yeah. Beyond repair.
Article 60 makes an interesting point about protecting the couple's privacy during this process.
Right.
It allowed the court to conduct, investigations and trials in private.
Yeah.
Shielding the couple from public scrutiny.
That's a really compassionate aspect.
It is.
Of the law.
Divorce is already
Yeah.
such a personal and often painful experience.
Yeah.
It is.
So it's good that they had that protection.
It shows a sensitivity
Yeah.
to the, emotional complexities involved. It's not just about legal procedures.
Right.
It's about recognizing
Yeah.
the human element.
Okay, so the investigation is complete.
Right.
All the evidence is gathered. The court has reached a decision.
Yeah.
What happens next?
Article 61
Okay.
sets a deadline.
Okay.
The court had 15 days
Okay.
to issue a judgment.
Okay.
And ideally,
Yeah.
according to Article 62,
Okay.
that judgment would be announced
Okay.
with both parties present.
What if one of them didn't show up
Okay.
for that final decision?
Right. If the judgment was issued in their absence, which is called a judgment by default,
Okay.
they had 15 days to file a complaint against it.
So there was still a chance
Yeah.
to challenge the decision.
There was. It was all about
Yeah.
maintaining fairness
Right.
and due process.
Okay, so someone files a complaint
Yeah.
against judgment by default.
Right.
But then what?
Okay.
Do they have to go through, like, another trial?
Article 63
Okay.
outlines the process.
Okay.
The complaint had to be filed with the same court that issued the original judgment.
Okay.
And it could be done either in writing or even verbally.
Oh, interesting.
The important thing is that this complaint put a hold on enforcing the divorce judgment until the matter was resolved.
So it was a serious legal action with immediate consequences.
It wasn't just a casual objection.
Okay. And Article 64 makes it clear.
That if no complaint was filed within those 15 days, the judgment by default became final, binding.
So clear deadline. If you missed it, you were out of luck.
What if somebody filed a complaint on time, but then didn't show up for the next hearing?
Article 65 addresses that. If they didn't have a valid reason for missing the hearing, the original judgment by default would become valid. And final.
So, again, you couldn't just file a complaint and then disappear.
Exactly. You had to actively participate.
But if they did follow the proper procedure for the complaint, Article 66 mandates that the court had to review the case and hold a retrial. They could uphold the original judgment, modify it, or even reverse it completely, as long as their decision was in accordance with the law.
It was a pretty robust system. It was with checks and balances at every stage.
And a good thing, right?
It is. It is.
It ensured fairness. Prevents hasty or biased decisions.
Absolutely.
Okay, so we've gone through this whole process. Reconciliation attempts. Investigations. Maybe even a trial. And finally, a divorce judgment is issued. What happens then?
Well, according to Article 67, the first step is to make it official. The court records the decision, sends a copy to the registrar, who then updates the marriage certificate to reflect the divorce.
So everything's properly documented, official.
It's all about closing the loop on the whole legal process.
It's interesting how much emphasis they placed on maintaining accurate records.
It speaks to a desire for order and transparency within the legal system.
But there's one more scenario I want to touch on before we move on. What if a wife is pregnant when the couple wants to get a divorce? Did that complicate things?
It certainly did. And it's here that we see a rather striking difference in the rights of men and women.
Oh, tell me more.
Article 68 states that if the wife is pregnant, the husband is prohibited from filing for divorce.
Wow.
Until a full year after she gives birth.
A full year? That's a long wait.
It is a long wait.
Why such a restriction?
Well, it seems likely that this rule was intended to protect the mother and child during a vulnerable time. And perhaps to, avoid any disputes about paternity.
So ensuring the child's well-being.
Exactly.
Preventing the husband from, abandoning his responsibility.
Right. But what's interesting is that this restriction didn't apply to the woman. The law explicitly states that she could file for divorce at any point during her pregnancy.
So there's a definite asymmetry there. In terms of, who has the right to initiate divorce when a pregnancy is involved?
It reflects a specific set of values and priorities that were present in Cambodian society.
At the time.
It
suggests that the mother's rights and needs were given greater consideration in this particular situation.
It's a fascinating insight.
It is.
Into how cultural norms can influence legal frameworks.
Absolutely. It shows that laws aren't created in a vacuum. They're shaped by the social context in which they exist.
Okay, so we've explored the complexities of the divorce process from reconciliation attempts to trials and judgments.
But let's say the divorce is final. What are the legal ramifications? What happens to the couple's property? And most importantly, their children.
Well, Article 69 gets straight to the point. The marriage officially ends the day the final divorce judgment is announced. There's no waiting period or anything like that. It's a clean break, legally speaking.
A definitive end to the marital contract. But what about all the stuff they accumulated during the marriage?
Right. Ideally, they worked it out themselves.
Okay.
Article 70 encouraged the couple to come to a mutual agreement about dividing their property.
So amicable settlements were preferred?
They were.
But what if they couldn't agree?
Right.
Did the court step in?
They did.
Okay.
And there were some default rules to guide those decisions.
Okay.
Each person got to keep any property they owned before the marriage, as well as anything they inherited or received as a gift during the marriage.
So it was theirs to begin with.
Exactly.
Acknowledging that individuals bring certain assets into a marriage. And those should be protected.
Exactly. And then any assets they acquired together.
Okay. The joint property.
The joint property were split equally between them.
A 50-50 split.
Yeah.
Seems pretty straightforward.
It does, but there were exceptions.
Okay.
Article 70 gave the court the power to deviate from this 50-50 split in special circumstances, particularly if it was in the best interest of the children.
So the children's well-being was a primary concern.
Absolutely. And they also considered things like whether one spouse had primarily worked outside the home while the other had, taken care of the household and children.
It's an important point.
It is.
Recognizing unpaid labor within the home is still a valuable contribution to the family's well-being.
They weren't just looking at bank accounts. They were trying to account for the different ways in which people contribute to a marriage.
What if during the marriage one spouse had damaged property belonging to the other?
Oh, interesting.
Was that taken into account?
Article 71 addresses that directly, stating that the person who caused the damage was responsible for it.
Okay, so acts of property damage within a marriage had legal consequences.
They did.
Okay, but now let's get to the heart of the matter. The children. How did Cambodian law in 1989 handle custody arrangements after a divorce?
This was a crucial aspect of the law. And Article 72 emphasizes that the court's primary concern was always the best interests of the child. They also took into account the concept of parental power, which encompassed, the rights and responsibilities each parent had.
So it wasn't automatically assumed that the mother would get custody, no, or the father?
No, not at all.
For that matter.
Right.
They weighed various factors to determine what was best for the children.
Yeah, exactly.
And Article 73 encouraged parents to try and reach a mutual agreement about custody arrangements, recognizing that cooperation between parents, even after divorce, was beneficial for the children.
It was.
So even in the midst of a separation, the law encouraged parents to work together. For the sake of their children.
It was about putting the children's needs first, even if the parents' relationship was ending.
But what if the parents couldn't agree? Did the court step in and make the final decision?
They did. And Article 73 mentions a general principle. If a baby was still breastfeeding, they would typically stay with the mother.
Okay, that makes sense from like a practical developmental standpoint.
It suggests a recognition of the unique bond between a nursing mother and her child.
Okay, so custody is sorted out.
Okay.
But what about child support?
Right. Article 74 is very clear on that. Both parents have a duty to financially support their children, provide proper care, raise them well, and ensure they receive an education.
Okay, so even though the marriage was over, shared financial responsibility continued.
Exactly. And if the parents couldn't agree on the amount of support, the court would decide, taking into account each parent's financial capabilities.
So the court had the authority to ensure that the child's needs were met.
And importantly, this financial support continued until the child reached the age of majority.
18 years old.
18 years old.
Okay, so even though the marriage is over, the financial obligations to the children remained.
It was about prioritizing the children's well-being, ensuring their future.
And what about the parent who didn't get custody?
Right.
Did they have any rights to see their children?
Yes, they did.
Okay.
Article 75 specifically grants the non-custodial parent the right to visit their children.
Maintaining that important parent-child bond?
Exactly.
Even if the parents are no longer together.
And the law went even further to protect those visitation rights. The custodial parent had to make it easy for the other parent to visit their children.
So it wasn't just a right, in theory. It was a right that was actively enforced.
Exactly. And if the custodial parent, made visitation difficult, the non-custodial parent could go back to court and request a change in the custody arrangements. Particularly if it was harming the children's best interests.
So the system had built-in mechanisms to protect the rights of both parents and to ensure that the children's needs were always paramount.
It was a recognition that that divorce doesn't sever the parent-child bond and that children benefit from having both parents involved in their lives, even if those parents are no longer married.
Okay, so we've covered custody and visitation, but what about alimony? Was that something that was addressed? We're back for the final part of our deep dive into the Cambodian law on marriage and family from 1989. We've covered how couples got married, that interesting divorce process, and even how they handled, marriages that happened in other countries. But now let's talk about, the heart of it all, the children.
Yeah, this is where things get really interesting.
It is.
Because, this law, while it was trying to establish some kind of stability, also had to deal with families that had been through a lot of upheaval,
You're right. And one of the things that really stood out to me was the distinction between legitimate and illegitimate children. I mean, those were actual legal categories back then.
Yeah, those terms, they sound kind of harsh today.
Yeah.
But we have to understand them in the historical context. It's really a glimpse into how societies, even as they're trying to modernize, they still have these echoes of their past,
Okay, so let's unpack these terms carefully. How did Cambodian law in 1989 define a legitimate child?
Article 82 sets the framework. So for a child to be considered legitimate, their parents had to be married when the child was conceived and born.
Okay.
And they also added a specific time frame. The child had to be born at least 180 days after the marriage or within 300 days after divorce.
Okay, so those time frames are really key. It seems like they were trying to connect the child's birth with a valid marriage.
Exactly. It all comes back to paternity, and making sure there's a clear line of inheritance. It's about establishing order, establishing legitimacy in a society that had experienced a lot of disruption.
Yeah, that makes sense in the context.
Yeah.
But those timeframes, especially the 300 days after a divorce, that seems pretty rigid. What if a child was born, a little outside that window?
That's where it gets a bit more nuanced. Article 83 talks about those situations where a child is born less than 180 days after the marriage.
Okay.
And in those cases, the child could still be considered the legal child of the husband if there was evidence that he knew about the pregnancy before the marriage. Oh. Or if he just, willingly accepted the child as his own.
So there was some flexibility.
There was.
It wasn't just about, dates on a calendar.
No.
They also considered, what the parents intended and what they actually did.
Exactly.
But what if the husband denied knowing about the pregnancy or just refused to accept the child?
That's a tough one.
It is.
Article 83 gives the husband, in those specific circumstances, the right to deny paternity.
Oh, wow.
And he didn't even have to prove that he wasn't the biological father.
So the burden of proof wasn't on him.
It wasn't.
That's a pretty significant exception.
It is. It suggests that the husband's word, really mattered.
Yeah.
And I think it reflects the power dynamics that often existed within, more traditional marriages. But again, this law was a product of its time.
Right.
Societal norms have changed a lot since then.
Yeah, that's a good point. It's a reminder that laws are constantly being reevaluated and updated.
Absolutely.
Okay, so we've talked about those edge cases. But what about the more typical scenario where a child is born within that 180 to 300 day time frame after a marriage?
Right. Article 84 deals with that. It says, in those cases, the law assumes the husband is the father. It's a legal presumption of paternity.
So it's like the default assumption based on when the child was born.
Exactly. But it wasn't, set in stone. The husband could challenge that presumption if he had reason to believe he wasn't the father.
Okay, so how would he go about doing that? Could he just say, nope, not mine, and that's it?
Not quite. Articles 85 through 89 outline a process for denying paternity. It's a formal legal process.
Okay.
The husband had to file a complaint with the court within 2 months of the child's birth. So there's a timeline.
So they were trying to prevent, like, delays and disputes.
Exactly. They wanted to establish paternity quickly and efficiently, and the husband couldn't just make a claim, he had to back it up. Article 86 lays out the criteria. He basically had to prove that it was physically impossible for him to be the father.
So he needed a pretty solid reason.
He did. He could argue, that he and his wife were living apart when the child was conceived, or that he had a medical condition.
Right.
Something that prevented him from, having sex or fathering a child.
So they weren't just taking his word for it.
No, there had to be proof. And it wasn't just the husband who could start this process. Article 87 says his relatives could file the complaint if he couldn't, like if he was incapacitated or had disappeared.
Yeah.
And if he died, his heirs could continue the case.
So this was a pretty serious legal matter.
It was.
With implications for inheritance and family lineage.
Absolutely. And if the husband's complaint was successful, Article 88 says his name would be removed from the child's birth certificate. The child would take the mother's family name.
There was a big legal and social change for the child.
It was. Article 89 talks about how important it was to keep accurate records.
Yeah.
The court had to send a copy of its decision to the registrar, who would update the child's birth certificate.
Okay, so they were very meticulous about making sure all the legal documents matched what was actually happening.
Exactly. They were creating a paper trail to show the child's legal status and who their parents were.
Okay, so we've talked a lot about legitimate children, but what about children who were considered illegitimate under this law? What was their legal standing?
Article 90 defines an illegitimate child as one born to parents who weren't married.
Okay, that seems straightforward, but I imagine the implications for those children were pretty complicated.
They were. It's important to remember this wasn't just a legal term, It carried social and cultural weight. Being labeled illegitimate could affect a child's inheritance, their social status, even their future.
Yeah, so it wasn't just a technicality.
No.
It had real consequences.
Real consequences. Articles 91 through 94 outline the process for recognizing illegitimate children, and it all depended on the parents.
Okay, so the parents had a big role in deciding their child's legal status.
They did. Article 91 says that if both parents told the registrar when the child was born that the child was theirs, then the child was legally recognized.
Okay.
Their names went on the birth certificate.
So if there was a united front from the parents, it was pretty simple.
It was. But what if only one parent wanted to acknowledge the child? That's where things get tricky.
So what happened then? Was the child just stuck?
Not necessarily. Article 92 says if only one parent recognized the child, then that parent was legally recognized and the other wasn't. So the child had a legal relationship with one parent, but not the other.
Okay, so it was a partial recognition.
Yeah, but it was something.
It gave the child some protection.
Exactly. And the law allowed for, changes of heart. Article 93 says that even after the birth certificate was registered, the parent who hadn't recognized the child could later come forward and claim them.
So there was always a chance for a parent to establish that connection, even if they didn't do it right away.
It shows they understood that people's circumstances can change, and that it's never too late to do right by your child.
What about if the parents of an illegitimate child eventually got married? Did that change anything?
It did. Article 94 says that if the parents got married, the child automatically became legitimate in the eyes of the law, like they had been born within the marriage.
So marriage provided a way to get full legal recognition.
Exactly. It shows they preferred children to be born within a marriage,
Right.
but also gave a way to fix things if things changed.
What if the parents just refused to acknowledge their child? Were those children left with no options?
That's when the court had to step in. Article 95 says the People's Court could force parents to recognize their illegitimate children.
Wow, so the court could overrule the parents.
They could, but only in specific situations. It started with a complaint. Articles 96 and 97 explain who could file that complaint and when.
Okay, so there had to be a formal process.
Right. The child could file a complaint for paternity or maternity themselves once they turned 18.
So they had that right as adults.
They did. But when they were minors, Article 97 says their legal guardian could file the complaint.
So there was always someone who could stand up for the child.
Exactly. Now, for the court to make a mother recognize her child, they needed evidence.
Okay.
Article 98 spells that out.
So it wasn't just someone making an accusation.
No. They had to prove the woman gave birth to the child, that the child claiming maternity was the child she gave birth to, and any other relevant evidence.
So they had to prove a biological link.
Exactly. Paternity, though, could be harder to prove. Article 99 lists several circumstances where the court could force a man to recognize his child.
So what were some of those circumstances? Was it all about biology?
It could be, but they also looked at other things. Article 99 mentions things like if the man eloped with or raped the mother and the child was conceived during that time. So the circumstances surrounding the conception were really important.
So they considered the context.
They did. They also looked at whether the man deceived the woman into having sex, if there was written proof he was the father, if they lived together, and if he acted like a father by supporting and raising the child.
So it was about his actions, not just biology.
Exactly. They looked for evidence that he was acting like a father, even if there wasn't clear biological proof.
But were there any limits on when a man could be accused of paternity? Could it happen years later?
Article 100 set some limits. They had to prove the mother and the alleged father had sex during a time she could have gotten pregnant. And if the man could prove he couldn't have had sex with her during that time, maybe because of a medical condition or because they lived far apart, then the complaint wouldn't be accepted.
Okay, so there were protections to prevent false accusations.
Exactly. And what about when the child was still a minor? Article 101 says either the mother or the legal guardian could file a paternity complaint for them.
So there was a way to seek legal recognition, even if the child couldn't do it themselves.
Exactly. And if the court decided in favor of paternity, Article 102 says it was as if the father had voluntarily acknowledged the child all along.
So it created that legal connection, even if it wasn't there at first.
Exactly. Then Articles 103 and 104 get into the child's family name. If both parents acknowledged the child, they got the father's name. If the court forced one parent to recognize the child got that parent's name. And if the court forced both parents, the child got the father's name again.
So the father's name was preferred.
It reflects, the way Cambodian society was structured at the time.
But did these children have the same rights as children born within a marriage?
Article 104 is really important here. It says that recognized illegitimate children had the same rights and duties as children born to married parents.
So they weren't punished for how they were born?
No. They had the same inheritance rights, the same social standing, the same opportunities. It was a big step towards equality for all children.
What about financial support? Were the parents obligated to support the child, even if the court had to force them to recognize them?
Yes. Article 105 says the court could order either parent to pay child support based on what they could afford.
So the court made sure the child was taken care of financially.
They did, and those payments had to be made regularly until the child turned 18.
Okay, so it was a long-term commitment.
It was. Article 105 also allowed parents to take care of their support obligations by directly caring for and raising the child.
So providing a home and care was also a form of support.
Exactly. And what about the costs of childbirth and early care? Article 106 says the court could order the father to pay the mother back for those costs.
So they made sure the mother wasn't unfairly burdened.
Right. And once paternity was decided, Article 107 says the birth certificate had to be updated to show that.
So keeping those records accurate was crucial.
It was. Okay, so we've covered legitimate and illegitimate children, but what about adoption? How did the law handle that?
Yeah, how did they approach that?
Articles 108 through 114 talk about adoption. It's defined as a contract that creates a parent-child relationship.
So it was a formal legal agreement.
Exactly, and they had rules about who could adopt and be adopted.
Like age limits.
Articles 109 and 110 spell that out. The adoptive parent had to be at least 25 and at least 20 years older than the child, and they could only adopt 2 children at most.
So they wanted the adoptive parents to be mature and stable.
It makes sense. They're being trusted to raise a child.
What about the child's age?
The child had to be under 8.
I wonder why they chose that age limit.
Maybe they thought younger children could adapt to a new family more easily.
That's possible. Was there anything else needed for an adoption to be legal?
Article 112 is all about consent. The child's biological parents or guardian had to agree, and if the child was abandoned, the authorities had to consent.
So they considered everyone's rights.
Yeah. Article 113 says the agreement had to be in writing and officially certified.
So creating a legal record.
Exactly. But it wasn't final. Article 113 also says the court could overturn an adoption if it wasn't in the child's best interests.
So they could check if it was done ethically.
Yeah, the child's needs came first. What happened once the adoption was final? Article 114 says the child took the adoptive father's name and had all the rights and duties of a biological child. They were fully part of the family.
Like they were born into it.
Exactly. Okay, so we've talked about marriage, divorce, children born inside and outside of marriage, and even adoption.
Yeah, we've covered a lot. What about just in general the parent-child relationship? Did the law have anything to say about that?
Yeah, Articles 115 through 119 focus on those rights and duties.
So it's not just about forming families, it's about what happens within them too.
Exactly. Article 115 says parents have to love, raise, and educate their children. They have to teach them to be patriotic, to love learning, to work hard, and to respect others and the law.
So it's about raising good citizens.
Exactly. And Article 115 also says children have to love, respect, care for, and support their parents, especially as they get older.
It's a two-way street.
It is. Were there any rules about how parents could treat their children? Article 116 says parents couldn't mistreat their children in any way. And that included stepchildren, adopted children, and even children from a previous marriage.
So all children within a family were protected.
Exactly. Did the law treat sons and daughters differently? Nope. Article 117 says they have equal rights and obligations in the family.
So gender equality is a theme throughout this law.
It is. What about when children become adults? Article 119 says once a child turns 18, and if they're living with their parents, they can choose their own job, participate in politics, and manage their own property.
So they get more freedom.
They do, but they still have a responsibility to the family.
A balance between independence and family duty.
Exactly. But families aren't always perfect. Articles 119 through 122 deal with revoking parental power.
So parents could lose their rights to their children.
Yeah, if they neglected or abused their child, violated their rights, forced them into crime, or behaved immorally in a way that negatively influenced the child.
It's all about protecting the child.
It is. How did that happen? Article 120 says the court can take away a parent's rights, but only if certain people file a complaint.
So it's not a light decision.
No. State organizations, community groups, legal authorities, or relatives could file a complaint.
What happens if they lose their rights? Article 121 says they lose all authority over the child, but still have to support them financially. Custody usually goes to a relative or another organization, so they still have financial responsibilities.
Yes, but there's hope. Article 122 says if parents change their ways and can prove they're fit to be parents again, the court can give them back their rights.
A second chance.
Yeah, if it's safe and what's best for the child.
This has been fascinating. We've really explored the Cambodian law on marriage and family from 1989. It's amazing what we can learn about a society by looking at their laws.
It shows how laws reflect the values and beliefs of a culture.
Yeah. And it makes you think about how our own laws shape how we live and interact with each other.
Exactly. And there are so many other legal systems out there, each with its own unique perspective.
We hope you've enjoyed this deep dive into Cambodian law and society. It's been really eye-opening for us. If anything we've talked about has resonated with you, or if you have any thoughts, we'd love to hear from you. Reach out and join the conversation. Until next time, keep exploring and keep diving deep.